Welcome everyone. Welcome to tonight's Acts 2 workshop, Dementia Caregiving and Family Estate Planning, Strategies to Prepare Effectively for the Future. I'm Dr. Rob Glukoff, servant leader of the Acts 2 project and professor at Florida State University, College of Medicine. In case you are unfamiliar with the term Acts 2, it stands for African American Alzheimer's Caregiver Training and Support Project 2. Folks, I am very enthusiastic about the prospect of tonight's workshop. The workshop offers practical information about developing a well-rounded estate plan to arrange and protect family assets and to develop advanced directives for your loved one with dementia. Our first presenter, attorney Jami Coleman, will focus on the basics in creating a last will and testament, understanding the pros and cons of trusts, and creating a living will. Our second presenter, social worker Stephanie Malally, will describe the core elements of advanced directives and how to interpret and complete them. Our third presenter, Acts 2 coordinator Tomeka Norton-Brown, will provide information about skills building and support for family caregivers of older adults with dementia, as well as dementia care resources. Before I introduce this evening's presenters, I want to recognize our partners who have contributed both resources and guidance in the development of the Acts 2 Dementia Caregiver Workshop Series. Acts 2's primary collaborators are the African Methodist Episcopal Church, 11th Episcopal District, the Florida Progressive Missionary and Educational Baptist Convention, the Florida State Primitive Baptist Convention, the Florida Church of God in Christ, and Florida State University's College of Medicine. Turning now to tonight's presenters, we have three inspiring speakers. Our first presenter, Jami Coleman, is founder of Coleman Law that specializes in estate planning, probate, tax, and real estate. She is a graduate of Florida State University's College of Law and has served as adjunct tax professor at Florida A&M University. She has held several leadership positions in several organizations, such as Legal Services of North Florida, Legal Aid Foundation, and FSU's Veteran Clinic. She has also served as a mentor for youth in Leon County Public Schools and for law students at FSU and at Florida A&M University. Particularly noteworthy, Mrs. Coleman was named the nation's best advocate under 40 by the National Bar Association. Beyond her legal career, she takes the most pride in being a mother. Our second presenter, Stephanie Malally, is medical social worker at Lee Health Memory Care Clinic in Fort Myers, Florida. She received her Bachelor of Social Work degree from Sacred Heart University in 2001. She subsequently obtained her Master of Social Work degree from the University of Central Florida in 2019. Stephanie has an extensive history of working with families in low-income housing and adults with memory loss. The last 9 years of her career have been devoted to ensuring optimal quality of life for older adults with dementia at state-supported memory clinics at both Orlando and Fort Myers, Florida. Stephanie enjoys this line of services and provides considerable support and resources to family caregivers and their loved ones with dementia. She is also currently co-chair of the Dementia Care and Cure Initiative Task Force for the Lee County region. Last, Tomeka Norton-Brown is coordinator of the Acts 2 project. She has worked in the area of survey development and evaluation for the past 24 years. Tomeka has served as a caregiver for her dear aunt and uncle with dementia and has a passion for serving others. She has been a great source of encouragement and support for literally hundreds of family caregivers of older adults with dementia across Florida and the U.S. Mrs. Norton-Brown is also a strong leader in her faith community. Folks, during the course of the workshop, I encourage you to share questions to be answered after each presentation using the text message function of Facebook Live. We also will have a 15-minute question and answer period following the last presentation. And now we have attorney Jami Coleman. Welcome, Jami. It's a great privilege to have you back with the Acts 2 Facebook Live workshop again.
Thank you. Good evening. I appreciate you having me. So I'll just jump right on into it. I want to just talk to you about strategies to prepare effectively for your future. Um, and I want to go through some basic tools. I call them tools for your estate planning needs. Estate planning is a fancy term for just getting your affairs in order. And I like to just try to remind um, people that it's not necessarily a doom and gloom um, thought process or perspective, but you're really thinking about your family in much of the same way that you think about them any other time of the day as you're going about your day. You know, what are we going to wear? What are we eating? What are we doing? But you're preparing for them when you're no longer around. And you're also preparing to conserve your assets. You're figuring out the best way to conserve and protect your assets for them when you're no longer able to take care of them while you're here. And so an estate plan is going to look different from one person to the next. It's very unique. And so the purpose of my presentation is really to help you focus on your circumstances and help you make informed decisions about what tools you need for your estate planning needs. Some of the goals, not these are not all goals, but some of the goals that people normally have when they come to see someone like myself or other professionals is they want to do long-term care planning. They want to protect their assets. They want to protect their family, and they're also planning for their family. Another common goal that I get is they want to avoid probate. Probate can be a very expensive process, and it's the legal process of getting assets out of a deceased person's name and putting it into the name of their loved ones. And so we want to try to do planning to avoid the process of probating because that can be a long, drawn out process. And practically, it could also inhibit and delay grieving. And so, what is this? What are some of the steps for estate planning? Well, I ask you to just gather your assets, just really take inventory of what you own and how you own them, right? How are they titled? Do you have bank accounts with shared owners? Do you have property that have shared owners? How are things titled? That's going to be very important. And then I want to talk to you about what are some typical tools that come or should come in all estate plans. And that's going to be your will, your power of attorney, your healthcare surrogate, and your living will. Now, there are some other tools that come in your estate plan, but those are the basic 4 documents that we're going to discuss tonight, okay? And then step 3 is arranging your assets based on your ownership to coordinate with your plan, right? So this is going to include whether you have beneficiary designations on some accounts, whether you have joint property and how is it listed? Is it, tenants in common, joint rights of survivorship? These are legal terms, but I'll do my best to get that information in within the 30 minutes that I have tonight. All right, so the first document I want to talk to you about that is a tool in your estate plan is your will. Now, a common question that I get is, do I need a will? And I would say yes, everyone needs a will. If you're 18 and older, you should consider having a will. And your will does really 3 basic things, right? So it tells me, how do you want to be buried? So if you have like a preferred burial or cemetery, or if you want to be cremated or have a green burial, that's the place to put that information in your will. So your family is aware of that. Second, it tells me who's going to make sure your wishes are carried out. So we call those people the personal representative or also the executor of your estate. Okay. And the third thing your will does is it says where you want your things to go in relation to the people that you care about, okay? And your will is the only document that we're going to talk about tonight that really deals with death or after you pass, okay? The other documents is about your lifetime. And so those are just the three things that I just talked about, what your will does. And so let's talk about trust, another tool in the toolbox of estate planning. There's so many different types of trust. We have the revocable living trust, which can be changed and amended during your lifetime as often as you would like. We have irrevocable trust, which is very difficult to change and amend. We have testamentary trust. Those are trusts that go into effect after you pass. And then there's also other types of trust that you can consider. Spendthrift trust, special needs trust, or protective trust. If you have a child or a family member that maybe needs to qualify for Medicaid, and giving them an inheritance or giving them substantial amounts of income or assets could, ruin their qualification for Medicaid, you can consider special needs trust. Trust for minors, so you can develop trust for minors that whenever they come into money, that if they get it sporadically or in intervals. There's asset protection trust, there's standby trust, so if you get a minor gets an inheritance or some large sums of money, or someone with a disability gets money, it can be held by their guardian or their loved ones. And so there's all types of trust, and it's more information that we have time to discuss, but I do want to give you a little bit of information about it because these trusts can help you and your family in your unique situations. And so another tool, the third tool I want to talk to you about, is the durable power of attorney. And this is probably the most important document in your estate plan because this document deals with your lifetime. And you are basically choosing an agent or your power of attorney to someone that you trust implicitly to deal with your financial and legal needs, right? So they can go into your bank account, they can pay your bills for you, they can sell your real estate, they can go into your email, they can act like you. And that's somebody that you really want to make sure that you trust implicitly because they have just as much power as you do. And so you want to choose somebody that's financially responsible, right? That's conservative, and that's going to protect your assets because what could potentially happen is if you don't pick the right person, they could wipe you out, And so the benefit of having a power of attorney right now is that while you're in good mental health and physical health, you choosing a power of attorney, if for some reason one day you become unable to make decisions for your own, unable to pay your bills, you don't know what day of the week it is, who the president is, who is standing right in front of you, you don't know what's going on. If you have some cognitive impairment, your power of attorney, your agent, the person you trust implicitly, can step in your shoes and transact business for you. And it might be a really good alternative to guardianship, which is a legal process that is court driven, that can also be very time intensive and it's inexpensive. And so an alternative to a guardianship is having a power of attorney and healthcare surrogate or advanced directives in place to avoid that. One of the most common questions that I get or comments that I get is, oh, when someone passed, I should be their personal representative because I was their power of attorney. Well, one is not the same. The personal representative deals with your will. Your power of attorney deals with your assets and your legal matters while you're living. So the second that person passes away, that power of attorney document is no longer effective, okay? That's how that works. The next tool in your toolbox is the healthcare surrogate. And the healthcare surrogate basically is, for lack of a better term, your power of attorney for medical decisions, your agent that you trust to make medical decisions. I'll share with you that my mother has a Google MD degree, is what I call it. She knows all things medical. And she is who I name as my healthcare surrogate. Likewise, she loves to shop at St. John's. And so she's not the best person for me to choose to be my durable power of attorney. And so, not that anybody that shops there has can't manage legal and financial matters, but I say that to say jokingly that you definitely want to make sure you're conscious and intentional about who you choose to be in these roles. What are their strengths? What are their weaknesses, right? And so, are they comfortable with talking to medical professionals? Are they going to understand? Are they going to get emotionally overwhelmed and not be able to comprehend and make medical decisions for you? Oftentimes, I get parents who want to name every child they have on both their power of attorney and on their healthcare surrogate. And what happens is you may have a child that's not financially literate, handling your financial and legal matters, and that may hurt you. Likewise, you may have a child that gets overwhelmed emotionally when it comes to medical matters. And so they may not be the best fit for the healthcare surrogate. So you just really want to be conscious and intentional about who you choose to be in these roles. And your living will. So we just came up on the anniversary of Terry Schiavo, and I might be telling my age a little bit, but for those that don't know, Terry Schiavo was a case where a young woman was in a permanent vegetative state, and her husband and her parents had a very long, very emotional legal battle about whether to keep her alive. And so this document became a huge conversation piece, and since that time, it's been ingrained to have a living will, more now than ever, right? Because if you find yourself in a permanent vegetative state, it's really best for you to make that decision as to whether you, one, even want that document or tool in your estate plan, but do you want to be kept alive by artificial means? That's really a very personal and intimate question that you should ask yourself, and that's what that document is dealing with. If I'm in an end stage, have an end stage illness, maybe I'm in a permanent vegetative state, there's no probability of me coming out of it. Do I want to be kept alive by artificial means? And so this is a document or tool that I ask people to consider. And not having it is a decision, but it is a tool that I at least want people to think about, because when you don't make that decision, your loved ones are having to make that decision for you. And so forms of ownership, we talked a little bit about that in the beginning. I kind of want to get into details about it now. There's so many ways that you can own your assets. So now we're talking about how do you own your assets and why that matters in your estate plan, right? So you may own your asset, be it your real estate, your vehicle, your bank account as an individual. You may have it joint with another owner. You may have real estate or property that's owned as joint tenants with rights of survivorship. That means that maybe three people own a real estate. When one person dies, the other two own it. When the second person dies, then the third person owns it in total or in fee. That's one way of owning property. Another type of ownership is tenants by the entirety. And that's a type of ownership specifically in Florida, where only married couples acquire the property. They get it at the same time, and it's for married couples. So your homestead may be owned as tenants by the entirety if you're married. And so knowing how you own property is important. And I want to just bring up homestead, for example. So if you have a husband and wife that owns the property or their real estate together, they own it tenants by the entirety, which means the marriage owns it. And if the marriage owns it, that means when one spouse dies, it automatically goes to the other, and there's no need to probate that asset. And that's important. Same with joint tenants with rights of survivorship. When one person dies, it goes to the other owners. But joint as tenants in common, when it comes to real estate, would have to be probated, because that means that each of the owners probably have an equal interest in that property. So even when one of them passes, their estate now becomes the owner of that deceased person's interest. All right, so assets that have some form of creditor protection. These are just some examples. We're so fortunate, for those that live in Florida, to have our homestead constitutionally protected, okay? And so what that means is creditors cannot get into the equity of our homestead, except the bank and except the government. So if you owe taxes, like property taxes, they're the only creditors that can really get into the equity of the home. Now, there always are exceptions, but your Discover credit card, your Capital One credit card, they're not going to be able to sue you and take your home, okay? Other assets that have creditor protection are your life insurance policies, your annuities, your pensions, your IRAs, your college savings accounts. These types of accounts and the others that are listed have creditor protection, meaning if you owe a debt, then typical creditors, general creditors, will not be able to access those assets. Now, cars, boats, planes, ATVs, a lot of people would consider those assets, but they can also be liabilities, right? And so we kind of refer to them as high liability assets, because they can be dangerous instrumentalities and they can do a lot of harm, not only to yourself, but to others. And so one way of protecting your other assets, should you find yourself in an unfortunate situation where others or yourself is hurt in a car, boat, plane, ATV, etc., is to have proper insurance. I'm not an insurance agent, but it's worth having a conversation with one, because if you do have other assets out there that are not protected, i.e., like your homestead or your life insurance policy, bank accounts are not protected. If you do have assets like that, then if you have high liability assets and you are sued and a judgment is awarded against you, well, then those other assets that don't have protections could be at reach, like your rental properties. And so you really want to be, careful about those high liability assets and making sure that you have sufficient insurance. So investment real estate, you'll notice here that that's not necessarily protected. However, titling your investment could protect your assets, okay? So if it's in a limited liability company, a family limited partnership, if you have proper insurance, if it's in someone else's name with little to no liability exposure, titling your assets is one way to protect them. Insurance. So again, I'm not an insurance agent, but insurance is a common way to protect your assets. So for those assets that do not have creditor protection, please consider whether you have sufficient insurance that could protect other assets that are not typically protected. And so let's talk about beneficiary designations. Beneficiary designations are so important. I have seen cases where your pension accounts and life insurance policies, even bank accounts, do not have beneficiary designations on them. And so oftentimes we have to probate that. Probate is expensive. And so it, like I said, it's also time consuming. And so in Florida, it involves the process most times of hiring an attorney. Okay. And so if you want to avoid that and have your loved ones get the money directly to them after you pass, making sure they're named on your beneficiary designation is paramount. You really want to look at that periodically to make sure that you have a beneficiary designation listed and that is who you want it to go to. Also want it to be in harmony. So your will may say, I want everything to go to John. But if your beneficiary designation on your retirement account was done 20 years ago and it says your best friend Susie, well then John's not going to get everything. And so you really want to make sure that your will and your beneficiary designations are in harmony. That's if you intend to do that. But you just want to be intentional about that and check on those things periodically to avoid some mishap later on. And so I think I'm right about at my time. I want to encourage you to have an estate plan if you don't already have one, and to know that your estate plan is an ongoing process. It's a living process. So you can change it at any time, but definitely consider having one. And at least have a will, a power of attorney, a healthcare surrogate, and a living will. And if you're unsure about what you need or what's best for you, what your unique circumstances are, please feel free to give us a call. Again, my name is Jami Coleman. My number's on the screen. My email is on the screen, and I'm happy to discuss whatever you need in terms of your estate planning needs.
Thank you so much, Jamie. That was an excellent overview of a very complex area, and you simplified the process for us considerably. Thank you. I have a couple questions for you.
Sure.
Many of the folks on the Facebook Live here are caregivers, and they may be in the position of wanting to uh, provide information to their loved ones with dementia early in the condition, so that they can make some intelligent decisions. When would you encourage them to use a revocable versus an irrevocable trust? And what are the circumstances under which you would use one or the other?
Well, I think that, early on. When would I encourage them to use it? Definitely early on, because as the disease progresses, it gets hard to convince someone to do an estate plan that involves even something as simple as a advanced directive, let alone a trust. Trusts are, I like to think of trust as not just a tool, but it's a way to control from the grave also. You're imposing conditions for when you're no longer around, or when you're not capable of managing the trust, right? And so when you would encourage them to do a revocable trust versus irrevocable trust really is situational and circumstantial. I have seen people put their life insurance policies in irrevocable trusts for tax planning measures and protections. But if you have some real estate and you just want to ensure that it's not being sold, or you have children that you want to make sure that they get funds in intervals, depending on what your condition is that you're imposing from the grave, it might be best to do a revocable trust and have successor trustees. As now, an irrevocable trust, they get hard to amend, So if something changes, if you wanted to change your mind or a circumstance change, you'd have to get the permission of all the trustees and beneficiaries to do that. And in some instances, a court order. So they become very hard to change. And so there is benefit to them. But I think as it relates to the example that you gave, I would start early on in the conversation and ask them, what are the conditions that you're trying to impose from the grave? I know that sounds a little bit morbid, but a lot of people come to me and they say, oh, I want to trust. I think we have to be careful about that, because when we see on Instagram and Facebook, oh, put everything in a trust, own nothing but have access to everything, or whatever they say, you got to consider the locality that they're in. In Florida, we have so many tools. Not only do we have trust, but we have ways to put our real estate, deal with our real estate. We have what's called ladybird deeds or enhanced life estate deeds. So typically when you see the advertisements about, hey, let's use a trust, it may be in a locality that does not have enhanced life estate deeds or ladybird deeds. They may be in a place where that, because they don't have that particular tool putting in a trust makes sense because it avoids probate. But we can give our property away right now during our lifetime. Those Florida residents, that is, we can give our property away during our lifetime, conditioned on our passing, and still retain ownership of that property. So we don't necessarily need a trust. And so you want to always have conversations about what's the condition, what's the purpose. Because when you hear trust, 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 the people who might be, advancing that may not necessarily be in Florida. And you just need to know what tools you have in the state that you're located in.
Well, that's just so helpful. I have many more questions, but what I think I'm going to do, questions for you, I'm going to postpone them until the last 15 minutes of our panel discussion. And now we'll have Stephanie Malally doing her presentation on advanced directives, how, when, and how to interpret them as well. Yeah. Stephanie, it's a great pleasure to have you back on the Acts 2 Facebook Live workshop.
It's great to be back, and thank you so much for having me. Definitely happy to be a part of this topic tonight because just like Jami mentioned, it's a very important one. So we are going to look at why advanced directives are so important. And starting off with what they are, it can be an overwhelming process, and there's a lot of different aspects. So for advanced directives, they are a legal document that really provides instruction for the individual's medical care. And it only goes into effect when they're not able to communicate their wishes or have lost capacity to make those decisions. And dementia is definitely a great example of a situation that can be that type of event occurring for the advanced directives to be in place. And we definitely want to make sure that the doctors and other providers that are involved in their care are aware of these directives for the medical treatment side of things. So that way the person's wishes are known, the planning of what next steps are if a circumstances arise. All those will come in play with this document. And research has indicated, and I can definitely see it with the work I do within the clinic, that having these advanced directives can definitely create more of a positive difference for individuals who have these documents in place because their wishes are being known. They have assigned that trustworthy person to oversee things, and everybody is on the same page. And then for the caregiver side of things, it's one less thing to maybe have to worry about and lessens the stress with, an event or with a journey that can already be stressful. So the types of advanced directives, and Jami definitely went into great information on these, are the living will. And this is looking at letting the providers know and the family, individuals, any medical providers, how the individual wants to be cared for or treated. If they are unconscious, cannot make their own choices on emergency care. I know for my mother, she had passed away unexpectedly, and so these documents were unfortunately not in place. And she had a brain aneurysm, so she was on life support, and my father had to make the decision, be it not an easy one, to remove her from life support and go, based on what he thought my mom would want. So if these documents had been in place, it would have made that decision a little bit easier, knowing what her wishes would have, what she wanted them to be. And with the durable power of attorney, this allows someone to be named as a proxy for these medical decisions when a person's not able to make those decisions. So they're, incapacitated, there's memory decline happening. So the proxy should really know what this individual's wishes are, what their values are, just really what their ideas of what they would want are. And like Jami mentioned, really someone who can be absolutely, completely trusted. Because I've definitely, unfortunately, seen situations where the individual has, been exploited, and financially, money has been used for not what its purpose was. So definitely trust is a very big factor. And, this can be a hard topic for people to want to discuss, but it's an important one. So, individuals may not be ready to make these decisions on who they want to oversee. And that's where the healthcare proxy, is a great way to be able to share your wishes. If certain things arise, this is how you want them to play out, or what next steps need to be, what your medical care needs to be, or what you want it to be, and based again on your values and preferences. So it's really important to get that person in place and make sure everybody is on the same page. So what are some important factors when we're looking at advance directives? Definitely, like I had mentioned, if the person is no longer able to state their wishes, someone else is going to have to do that for them. And so that's why making sure it's someone you trust, family, friends, if there's maybe limited family, having those open and candid conversations about next steps and your wishes need to occur. And definitely agree with Jami saying if we're 18, and over, it's never too early to start planning. Even if, we're healthy, everything's going fine. It's always good to have things in place because we just want to be prepared. And there's also, durable power of attorney for financial planning as well. So looking at the individual's finances, what their wishes are, if it comes to long-term care planning, and if their needs increase to where they may need a higher level of care or help within the home, what does that look like? Does the individual want to stay at home for the longest amount of time possible? Are they open to going to maybe assisted living, memory care, long-term care facility? If they have choices or ideas of what that looks like, this is the opportunity for them to share them. And it's important to do these things early on, especially if memory is a factor or part of the equation, because eventually the individual will get to a point where they're not able to make decisions for themselves legally, ethically. So having these conversations early on and bringing it as a team approach, can help make it a little less stressful, have it be a conversation when maybe all the families together, getting everybody's feedback of what their wishes are, what their thoughts are about planning and advance directives can definitely be helpful because we're brainstorming, we've got the family there, and it's just an open dialogue. I remember my grandmother had a will and had her documents in place. And even though I wasn't power of attorney, she wanted me to view them just so I'd be aware of what her wishes are. And initially I was like, I don't want to, to me, you're going to live forever. And I just don't want to think about it. But I took a few minutes and realized, yes, I definitely want to be a part of this. I want to know what her wishes are. And that way I can be of support as anything arises. So a couple of medical decisions to consider are do not intubate order. So this lets the hospital or medical staff know that the individual does not want to be on a breathing machine. Or do not resuscitate. So if by chance they lose a pulse, they stop responding, they stop breathing, the individual may not want CPR or other life-saving measures to occur. So these are definitely important and are a lot of thought go behind these items as well, because not only would the individual, if they're able, but the power of attorney sign, and then their medical doctor as well. So again, these are very important topics, and a lot of consideration needs to be put behind them. So how can we start planning? Again, it's never too early. Having conversations about what our thoughts are, what our beliefs are, what we'd like to see happen are so important. I definitely started this process before I moved to Fort Myers, so I need to pick it back up. But I have other things in place, so that way, if anything arises, things are going to get addressed. And we want to make sure that these important papers are in one location and we know where they are in that power of attorney, or if there's a couple power of attorneys or, primary, secondary, that they're aware of where they are. So it's good to have the original documentation and copies, and even a folder created. So if the person gets hospitalized or, goes into a higher level of care, skilled nursing, there's copies already made for the facility, for the hospital, to know what their medical wishes are. And we definitely want to keep them updated because things can definitely change. It's also looking at whatever state we live in. There can be different regulations and legislation in place. So if we move, from one state to another, definitely touching base with an elder law attorney or estate planning attorney to make sure that we've got everything covered for where we now live. My aunt and uncle moved from Illinois to Georgia. So when I was talking to them, I was, recommended them to definitely touch base with an attorney to make sure everything is covered. There's no changes that need to occur. And then, of course, if there's any medical changes, personal changes, divorce, things of that nature, all those things would encompass updates. And then we want to make sure that our medical providers and the attorney have permission to communicate with one another if necessary or whenever necessary. So that way everybody's on the same page and the best guidance can be given. So getting started, we definitely do not want to wait until a medical event has happened and we're in crisis mode. Being proactive and being as prepared as possible is very important. So everything can be fine, no health issues, but just being able to take time to think about what we want, to have conversations with our family or the person or persons we want to designate. Taking those steps is so important. And then connecting with an attorney to put them in play. I know I've spoken to my one cousin about being my primary power of attorney, and I'm choosing another family member to be my second. So that conversation will be happening as well. So it's definitely important factors. And looking, like I've stated, with their values, their wishes, medical treatments. Do I want life-saving measures? Do I, want to be on breathing machines? Things of that nature. And people, sometimes they do want those life-saving measures, and other times they do not. My father also passed away unexpectedly, so these documents were not in place, and everything happened so fastly. So, the family did and I did the best we could with making medical decisions, next steps, and then for the financial component as well. And it definitely being flexible and taking it one step at a time, because it can be overwhelming, and just making those decisions that we wouldn't necessarily be like, oh, I do have to think about that. What would I want? It can take time. So it's okay to change our mind if we want to update. I know initially I wanted to be buried and, have a casket and everything. And now I want to be cremated. So, our ideas can definitely change. And an attorney can be consulted to provide the legal guidance. So that way anything needs to be modified and, can be done in the best manner. So that way the person's wishes still can continue to be met in the best way possible. So once the documents have been created, we've got our estate planning done, definitely keeping our family updated, especially individuals we have chosen to be our power of attorney or healthcare surrogate, letting them know, providing them a copy, letting them know where the document is, and then also providing it to our primary care doctor or any providers or specialists that we may regularly see, so that way it can be put in our chart. If the individual's in a hospital system, a lot of times if they're seeing the doctors within that same hospital system, one doctor uploads it, one office, the other providers and offices are going to be able to see the document. So that's a big help. So, we're not having to provide it to each and every one. But it's definitely important for all the pertinent parties to be aware of what is outlined and to have a copy, especially if there's like a do not resuscitate order. There's, it has to be on yellow paper. There's certain things that they look for. And I know a lot of people, if they do have a DNR, they have it on their refrigerator in their home. So if 911's called, first responders come in, that's something they'll look for in regards to providing next steps. So definitely good to be aware of that. And how can we start the conversation? It definitely can be nerve-wracking, but it's so important, and it can go smoother than we maybe expect. At the end of the day, we want to make sure our loved ones' wishes are being taken into consideration, what they want, how they feel. And we're doing this out of love. So I love you and wouldn't want to do anything that you did not agree with. So it helps me to know what is important to you. If anything were to come up and you were ever too sick to not be able to make decisions, what would you want? What are your wishes? Sometimes I've seen where family members, if they've been there gathering for birthdays or family reunions, that's been the time that they've brought this topic up and had conversations. So that way the family's together, they're all giving their input, and especially talking about too what they would want for their wishes. So it can help flow the conversation. Or if there's a movie, that touches on end of life, someone's passed away, or there's been healthcare crisis, asking, what would you have done? That was, this character so-and-so had to make a tough decision, and but she honored her loved one so well. Taking that into consideration. And then if there was, a family member that passed away recently, and, circumstances that entailed, or maybe they didn't have these documents in place, kind of talking about how that made our loved one feel, what things that they maybe would have done or would want to do. So there's definitely ways to bring the topic up in a graceful, if you will, way. So that way these areas can be addressed and things can be put in place. So when we maintain our advanced directives, we definitely want to make sure we are updating them as necessary. And it's good to review them at least once a year, just to make sure that nothing has changed, that there isn't state law that has changed, that maybe something new has to be incorporated to make sure it's still on point. And like I mentioned, if the individual has moved from a different state, that's always important as well. And there are things that can change or impact the advanced directive, from divorce, death of a loved one, even change of employment or retirement. So those are things that can be taken into consideration. I know several years ago, I owned a home. And initially, I did have documents in place and it had my home and certain other things. And now that has changed. So that's another reason why I'm looking to update my documents as well. And also health wise, if any new diagnoses arise, definitely incorporating that and having that be a factor is important as well, because I see a lot of times, especially with spouses, the one individual has their spouse or significant other as their primary, but now the spouse or significant other has been diagnosed with dementia and it's progressing. So there definitely needs to be some changes with that aspect. So I wanted to give a couple examples of advanced directives. There's a very popular document that is out there called the 5 Wishes, and you can find it on www.5wishes.org. And it asks questions and let you deep dive into what your wishes are, what your values are, what you would want if something were to occur. And then Empath Health has a great appointment of healthcare surrogate and living will. So I have provided the website there. And then last but not least, the Agency for Healthcare Administration has a PDF or the form for the living will for Florida. So you can get an idea of what is entailed, what questions are asked, how the form is, formatted. So definitely wanted to give some examples of that as well. And then lastly, I wanted to provide my contact information. So I am located, as Dr. Glukov said, at the Memory Care Clinic for Lee Physician Group in Fort Myers. So if anybody has any questions or a need of resources for this topic, please feel free to reach out because I'm definitely here to help. And Jami does amazing work. So got a great resource here on tonight's Facebook Live.
Thank you so much, Stephanie.
And
That was not only very comprehensive, but you came up with some very good illustrations, personal ones, about key issues with advanced directives. And I thought that was particularly helpful. We have a comment from dear Susan Epstein, a colleague of mine. I think hospitals make you sign something before operations. Is that only if you have not provided advanced directives?
So, Susan, that is a great question. And yes, I've had a couple surgeries within the last few years. And since I do not have updated advanced directives to provide, they did ask me if I had any advanced directives. And because I did not and chose not to, there was a form that I signed to just confirm that. So that way they were aware in case, God forbid, anything happened during the procedure. So thankfully nothing did, because it definitely is eye-opening when, that was my first surgery ever in life. So it was a little scary. So it definitely pushed me more to look at getting them done for myself.
And I just have one more brief question for you, Stephanie, at this point, others later on in our panel discussion. To what extent are you're a memory disorder clinic coordinator that's associated with a state-supported clinic. We have 17 across the state of Florida. To what extent are you involved personally and other social work coordinators in facilitating the adoption of advanced directives in your work with loved ones with living with dementia and their family care partners?
That is a great question, and thank you. So anytime I meet with a patient and or family, I have two questions that I ask right off the bat because one helps guide the conversation for me, and two, I can make sure I've hit on the topics because this one is such an important one. And that is, does your loved one have advanced directives? And do you have long-term care insurance, or what is the financial situation? And that way we're able to start discussing, and I can share, because sometimes I've gotten looks like, nah, I don't have to worry about that right now, or things are early on, but then we're able to have open conversations of the importance, what next steps to take, and then I'm able to provide resources or direct referrals to great resources like Jami, or the Florida Senior Legal Helpline, to be able to make sure those things can be put in place.
Thank you so much, Stephanie. And we'll pick you up in the panel presentation. And now we have Tomeka Norton-Brown, Acts 2 Project Coordinator. Thank you, Tomeka, for being with us this evening.
Thank you. What I am going to do is to provide information about our Acts 2 project. You can go to the next slide, please. We're now going to talk about our Acts 2 program of services. As you all know, Acts 2 stands for African American Alzheimer's Caregiver Training and Support Project 2. We offer three major types of services. The first is our faith-integrated group skills training and support for distressed African American caregivers of older adults with dementia across Florida. We also offer dementia awareness presentations and workshops at faith, community, and eldercare venues, as well as social and print media across Florida and the U.S. And then individual telephone-based problem solving and information and referral consultations to all dementia caregivers and other stakeholders across Florida and the U.S. Let me also state that every service that we provide in Acts 2 is free of charge. So any caregiver who reaches out to us, whether it be for our 12-session program, whether it's a group wanting a dementia awareness presentation, or for individual telephone-based problem solving and information and referral, will never incur any charge for taking advantage of the services that we provide. Next slide, please. I'm now going to give more information about our 12-session program. Let me state that our 12-session program is for African American caregivers and relative, and we loosely define relative. So I said you can either be related by blood or related by love. Caregivers residing within the state of Florida, spending 6 hours a week in their caregiving duties does not mean that that person needs to live in the home with you and you're experiencing distress in your caregiving. For our program includes 7 group skills building. So we pair 3 caregivers in a group and 5 individual sessions. All of the sessions are delivered weekly over toll-free telephone by our trained lay pastoral care facilitators. Let me just stop here and talk about our lay pastoral care facilitators. Those are simply lay persons from the faith community who have either been nominated by their judicatory leader or they have self-nominated, and we train them to deliver our 12-session program. Our individual sessions, so those 5 individual sessions with the facilitator, will focus on goal setting and problem solving to address those concerns that have been identified by the caregivers. Most caregivers who come into our program have 2 or 3 things that they really want to work on. Some of those goals are caregiving related, and some of those are personal in nature, but they get 5 weeks one-on-one to work on coming up with strategies to help them achieve those goals. Next slide, please. What are the contents of our modules? We have 6 major components. The first is an overview of the basic characteristics of the dementias, or Dementia 101. We do relaxation training combined with calming prayer and or meditation. You'll hear me talk a lot about faith sharing and calming prayer, meditation, etc. We are a faith-based program, which means that we have woven those elements into our program and into our services, but we're also ecumenical. So if a person does not profess a particular faith, it will not prevent us from providing services to them. We also work with our caregivers on effective thinking about the challenges of caregiving coupled with scripture. Next slide, please. We have my favorite module, but the hardest for me to do. It's the me time module. Just building in pleasant daily activities as a guard against emotional distress. Just being able to negotiate 15 minutes so that you can take a walk or listen to your favorite type of music. We also work with our caregivers on communicating effectively, not only with the care partner with dementia, but family and other health professionals. And then lastly, on developing those effective problem solving skills through personal goal setting. Next slide, please. When we talk about dementia awareness training, now, as I said before, this is a service that is free to any group that that reaches out to us and wants this service. Our staff members will deliver both in-person and virtual dementia awareness training to family caregivers and other interested parties. Some of the example topics that we cover are the basic information about the characteristic and stages of dementia. We also cover risk factors for Alzheimer's disease and related conditions, and also strategies for preventing or delaying the onset of dementia. Next slide, please. When we talk about individual problem-solving consultation, this service is available to any person, regardless of race, regardless of location. So 1 or 2 problem-solving sessions are delivered over a toll-free telephone by ACTS2 staff members. The caregiver prioritizes 1 or 2 goals, and they will work with the facilitator in developing an action plan. Some of the most common problems that we work with people who reach out to us on are they're having difficulties with bathing and hygiene of their loved one. They're having challenges with their loved one eating, and in difficulty getting help from family members. Next slide, please. Another service that is available to all caregivers, regardless of race, regardless of location, is our information and referral consultation. So there again, 1 or 2 INR sessions delivered over toll-free telephone by our ACTS2 staff members. The caregiver will prioritize their INR goals, and we work with them on developing an action plan. And some of the more common INR concerns are they want to identify affordable caregiving services. They want to find culturally responsive adult daycare centers, and they want to locate effective estate planning assistance, like our dear Jami, who's presenting here tonight. Next slide, please. Next slide, please. Next slide, please. Okay, and here are some dementia care resources. There's the Florida Department of Elder Affairs, the Alzheimer's Association, the Alzheimer's Foundation of America. There's the Elder Helpline, the Eldercare Locator, and the Alzheimer's Disease Education and Referral Center. Next slide, please. Interested caregivers can learn more about ACTS2. You can reach us through phone, email, or through our website. You can contact us toll free, 1-866-778-2724. My local to Tallahassee cell phone number, 850-274-4945. My email address, tnnorton at fsu.edu. You can also contact us here on our Facebook page, Acts 2 Caregiver Project. You can send a message, and we do respond to those messages. And you can also go to our website, www.acts2project.org. And what we're now going to do is bring up our website and take you on a tour and show you some of the resources that are available there. So if you will bring up the website, please. Okay. This is our new and improved X2 website. If you will click on Program of Services. Okay, there appears to be a delay, but if you go to our page where it has the program of services, it has all of the information about Acts 2, what our services consist of, more detailed information that I provided a moment ago. If you will click on Caregiver Resources. Okay, if you will click on Caregiver Resources. Okay. While we're waiting for that page to populate, on our Caregiver Resources page, there is a listing of all of our former webinars that we've done. You can find those on that page. There are also links to Florida-based resources and also national resources. There are prayers and readings. There's information on the basics of dementia. This page is a good starting point if you just want to get some information to know where to start your question asking. I always tell the caregivers that I speak to check this page out because there's a ton of information there. If you will go back up to the top and click on donate, please. If you will click on donate. And while we're waiting for that page to populate, on our donate page, if you're interested in learning more about how Acts 2 is funded, why to support Acts 2, all of that information can be found on our donate page. Okay, if you will go back up and click on contact us. Okay, on our contact page, if you just have a question or if you're interested in signing up for the program, you can come to this page, fill out the contact form. It will route directly to my email. So even if you just have a question, even if maybe you're watching the live and you didn't catch Jami or Stephanie's contact information, you can come to the website, fill out this contact page, ask whatever your question is. It will come to me, and then I can reach back out to you and provide the information that you needed. That concludes the tour of our website. What we're now going to do is have all of the panelists come back up to prepare for the Q&A portion of our workshop. And I know that after you all have watched this and gathered all of that useful information, I'm sure that you have questions that you would like to ask the presenters. And now is the perfect time to ask those questions.
Well, this is quite the dream team that we have this evening. Those presentations were really outstanding. Thank you so much. This is such an important topic and needs to be addressed not just once, but multiple times because it it is so important to the welfare and integrity of loved ones with dementia's assets and the family caregivers who support them. Okay. We do have a, a question from Angela Whitaker. Thank you, Angela, for bringing your question to the table, so to speak. Is a lawyer required, Attorney Coleman, to prepare an advance directive or living will? Or is there a form that can be notarized?
Yeah, so Stephanie did her presentation was amazing, so thorough, very nice. Thank you. And I
Thank
especially
you.
love that you brought in some very personal things that have occurred in your life. So thank you for that, for being so transparent. But in Stephanie's presentation, she provided at least three resources where you can download a living will and advance directives. So no, you do not need an attorney.
Could I ask you, though, Jami, as an attorney, I know you're not tending to be self-serving. You don't need to be. You have a very active practice. I know that from experience. But bottom line, uh, how do you differentiate when you can complete a form, advanced directives, or even what's now available online, wills, you know, and the need for consultation
Right.
from an attorney, a licensed attorney?
That's always hard because people don't know what they don't know. And I'd love to hear what the street lawyers say about the practice of law and probate and estate planning. You wouldn't believe some of the stuff that I hear. But you know, you can, when it comes to like living wills and healthcare surrogates, those documents are pretty self-explanatory. You can, really download those and you don't need an attorney. You're really just designating a proxy to make medical decisions for you. And you're also deciding how do you want to spend the rest of your life, what's remaining anyways, should you find yourself in a condition where it's in end of term or you're in a permanent vegetative state. So those documents are pretty self-explanatory. I really like the five wishes document. I think they're very simple and easy to understand. But when it comes to powers of attorney or durable powers of attorney rather and wills, when it comes to trust, I do think it's best to consult with a professional regarding those documents because they can be complicated. For example, I have seen wills that say, hey, I want my homestead sold. When I pass, I want it sold and I want the proceeds divided amongst my children. Well, what happens when you do that is now it's no longer constitutionally protected. Remember, for every rule, there's an exception. And so when you say you want your homestead sold in your will, well, now the creditors can attach to the proceeds of the sale. And typically the rule is it's protected, right? That's what I went over. But when you don't know that, you end up causing a lot more headache for your family than if you had consulted with a professional. So there's so many like nuances to the law. And so when it comes to those documents, which may seem simple enough, spending the money to do a consultation is worth it.
Thank you so much. I have a few questions. I promised that I would. I'm going to start with Jami. Jami, this might sound overly simplistic, but it may not be. It may be somewhat deceptive. What is the the difference between a living will and advance directives?
So, advanced directives is a very broad term that encompasses the tool of a living will. Remember, I've got an estate planning toolbox, and a living will is one of those tools in the toolbox. And when it comes to advanced directives, that is one of the tools, one of the directives. So they are one and the same, but advanced directives could also mean your healthcare proxy or medical surrogate designation form, as well as your as well as your durable power of attorney. So those are all documents when working together are all encompassing of advanced directives. So advanced directives, again, it's just a really nice, general, broad term that means any one of those documents or all of them together.
Thank you. Well, that leads to my second question, which is durable a power of attorney equivalent to a health surrogate, or are they different from one another?
So really good question. A durable power of attorney can have a medical surrogate provision in it. So you can have a document that says, hey, I want this person to handle my financial and legal matters and also handle my medical matters as well. That can be in your durable power of attorney. My preference, though, is always separate those because the person that can make medical decisions for you may not necessarily be the right person to make financial and legal decisions for you. And so I try to keep those documents differently. Unless you trust that person implicitly to do both, then there's no issue. But oftentimes you may have different people serving in those roles. Also think that it can also be cumbersome for medical professionals to see 25 pages of a document and they're flipping through and they're trying to get to the healthcare surrogate part. And so to simplify things, instead of giving them that 25-page document, which is the power of attorney, they have a 2-page document with this, or a 1-page document, which is the healthcare surrogate. And so for those reasons, it's my preference to keep them separately, although they can be combined.
Thank you. I believe that this is the case, that the term health surrogate is used in the state of Florida, but it may not be used in other states. Is that correct?
I actually don't know the answer to that. I don't practice anywhere but Florida, but I have met other practitioners who use the term healthcare surrogate as well. They also use the term medical proxy. They
Very
also
good.
use the term as medical agent. So I think those terms are interchangeable, but yes, every state could have different terminology or could have unique terminology that essentially means the same.
Surrogate's kind of a big word. What does it mean?
You'd ask me a question I don't know. Let me go look it up. But essentially, what we're talking about is the agent. We're talking about the person that's standing in your shoes to make medical decisions for you. They have a HIPAA release. They can talk to your doctors. They can decide whether it was procedure A or procedure B. They're standing in your shoes. And so they're not your per se, but they are your agent or surrogate in that way.
Thank you. Well, here I got a couple general questions for the group. Okay, you can also raise your own questions so I don't have to flap my jaw all the time. Well, here's the general question for each of you. How can we best promote the use and actually the creation of wills, living wills, trust in the community of caregivers of loved ones with dementia and persons living with dementia who are still capable of participating in the process of developing those documents? How can we best, when we think community and agencies within those communities, how can we as persons invested in the quality of life of persons with dementia and their care partners, how can we best ensure that the word gets out and is infused within the community of potential users?
That is definitely a great question. And it definitely takes a village, for sure. And I know for me specifically, since my role also encompasses outreach and education in the community. So I take every opportunity that I can, not only when I'm in the clinic with patients and their families, but when I'm out in the community to talk about advanced directives, the importance of them, how to get things started. So it's part of my everyday conversation, to be honest. So to help get that word out, because I truly believe knowledge is power. And so the more we can have it be a regular part of our conversation, make it routine. Hopefully it'll, continue to make people realize how important it is, because I've definitely had conversations with individuals a few times about this topic, because they're uneasy, they're nervous, they don't feel they're ready to do these documents. So, it's just being that support and reassurance as well.
I would agree
Tomeka,
with
your
Stephanie.
thoughts, please.
Yeah, I would agree with Stephanie. I think it's so important for you to get out into the community, and not only and we're also such busy individuals, but it's so important to take time to be approachable and have these conversations. And I always like to start with changing your perspective on these issues, just changing your paradigm. So many people, especially in the Black community, we are avoidant about having this kind of conversation, end of life and planning. But this is really how we not only protect our families, but and not only help our families, especially those that are suffering from some cognitive impairment like dementia, but it's also a way for us to continue to preserve and build generational wealth. And that's such a crucial uh, point, or element that I like to kind of just stress to our community, is that you're really planning not only for your life but for your loved one's lives.
Mhm.
And when you invest in elder planning or long-term care planning, Medicaid planning, your state, your affairs, you're really setting your family up to be able to continue to keep the assets that you've worked so hard to acquire and to keep during your lifetime. And so I think it's so important to just change our paradigm about it. It doesn't have to mean that, oh my God, if I have this conversation now, I'm going to die tomorrow. So having that, being out in the community and just explaining there's another way of thinking about this. You are thinking about your family. You are caring for them in the same way that you do when you bathe them, in the same way that you do when you feed them, in the same way that you do when you provide for them. You are caring for them in that way. And so if we are able to just express that more and get out into the community, get ingrained into the community, we'll find that people trust us more and they'll be open to having the conversation. And like Stephanie said, it's got to be a repetitive, continuous conversation, right? I'll tell you that I've had this conversation with my parents for years, maybe 10 years or so. They finally came into the office last year and signed it. But it took a while, and it took them, having those conversations and changing their paradigm in order for them to do that.
Thank you. Tomeka, your thoughts, please. And you can even mention efforts that are underway to do it in the community in which you're participating.
I think it's like Jami said earlier. The most important thing is to make it a topic that does not have the stigma attached. Like Stephanie telling her personal story about, what she went through. When I'm talking to caregivers, I'm open and honest about, all of the things we lost of my aunt and uncles that they had worked so hard for, simply because there were not things in place that protected their assets. And so it's all about being open, being honest, not being afraid to ask the difficult questions, and removing that stigma of, now you want to get in my business and take all of my stuff. And that's why we're having this conversation, because that's the first thing that people assume. But to Jami's point, it's about protecting what you have and what you worked so hard for, and making sure that your kids and your kids' kids and your kids' will have something that they can fall back on. I know one of the great things that's going on here at Big Bend Hospice has started doing workshops on the 5 wishes and advanced directives, and they're like willing to come out and do those workshops for churches or other groups, just to get that information. I heard someone say before, you don't know what you don't know. And in our community, specifically in the Black community, we have to stop being afraid to get the information. Getting the information only empowers us. It doesn't hurt us. It can only help us. So there's so many things that the stigma has to be removed from, and this is just one of the things that stigma needs to be removed from.
Thank you so much. Another question for you. Your sense, and then I know this is going to be maybe just a brief response, but it's a difficult one. Maybe just a touch upon, but it's worthwhile bringing it to the table now. How do you have any thoughts or strategies that you suggest to others, Stephanie and Jami, Tomeka, for selecting who's going to be your power of attorney and or health surrogate, health proxy among your family members and friends? On what basis do you select those persons? It's kind of difficult to sometimes even to know how to make that judgment. Just your one or two reflections about that before we end with some affirmations and final comments.
Yeah, I think it's best to, when it comes to power of attorneys, like I said, the durable power of attorney document is the most important document. That person can literally wipe you out. And I have heard horror stories about how a spouse has wiped out another spouse because there were superpowers and they were able to gift themselves gifts and change beneficiary designations and take loans off of their IRAs. But they were named as the power of attorney. And so they had those powers, but they were not financially prudent and conservative. And so, as Stephanie had mentioned earlier, these are living documents. And as your circumstances change, you need to evaluate whether the person that you have selected to be in those roles are still best fit. Because who I select today may not be still the same person or the best person 5 years from now. You definitely want to do it while you're healthy, but you got to consider, when it comes to financial legal decisions, are they prudent? Are they always in debt? Then you probably don't want to use them. If they're always asking you for money, then you probably don't want to put them down as your power of attorney. I've get parents that want to put all their kids down as power. I don't want Johnny to feel left out. Well, Johnny has a habit that inhibits him from, taking care of your money. He's always asking you for money. Don't do this to appease Johnny. You got to protect your assets, conserve your assets. So you want to make sure you're continuously thinking, is this the best person? And as you see things that concern you, then it might be time to have that conversation to make the change.
That's so helpful. Well, Stephanie, you have a comment?
Just something to piggyback off what Jami's saying too. Also, something I would take into consideration is who has been there for me within the family, because we have where there can be fly-by-night family members where they only come around when money's involved or something like that. But when it comes to the bad time, like the good times, the bad times, the indifferent, who is there, stood by their side to coincide with the trust, and who can make great, good decisions financially and medically.
Yeah, Jami, just a quickie question for you. You raised this point. if there is that one relative that you don't want to offend because that, or say child, and there are 4 children and 3 work, but one is an outlier, you don't want to mention that to him because he'd be offended. How do you negotiate that process with your client to be assertive in that situation? What strategies do you suggest?
Fear. Just seriously, I have to tell them, because while I do estate planning, I also deal with when you don't have an estate plan and you have to probate your estate. I also deal with breach of fiduciary duties or exploitation of a vulnerable adult. And so what I explain to them is like, look, I know that you are, trying to consider Johnny's feelings. But Johnny doesn't know about this document unless you share it with him. That's one. And two, you really have to do what's best for yourself, because if you know Johnny has a habit, he has the ability to wipe you out completely. He can take all of your funds, and there's no recourse for that once it's gone. Yeah, we can go to court, but if money's gone, money is gone, And so I want you to think about, my job is to plan for you. Okay.
Mhm.
And what I want to do is make sure you're protected. So if Johnny is not best suited to be your power of attorney, well then my best advice is not to name him as such. And I usually don't get pushback about it. I get the, oh, I'll think about it, oh, I'll pray about it. But after some time, they usually agree, because they know their children better than I do, or they know their loved one better than I do. So but I also say, hey, you know what? Name him here. Name him as the healthcare surrogate. Maybe he's the 4th one down the line, or the 3rd one down the line. So when he
Yes,
sees
good
his
point.
name, he's like, oh, she did think of me. She did give me a role. But you have 1 or 2 or 3 people ahead of Johnny. And so that's, that's a, if you think that Johnny can make medical decisions for you, that's something that I would encourage
That's
them.
very, very thoughtful. Uh, Esperance, would you please share the affirmations? Yes. Johnny Livingston Lee, so glad you're with us, Johnny. Your affirmation. Thanks to all presenters for information shared. I have heard about all, however, I haven't completed any forms, but I will ASAP. Way to go, Johnny. Thank you, Mrs. Livingston Lee. And we have Haley Bond providing an affirmation for this esteemed group. I am a Master of Social Work student, interning with my local hospice agency. This has been very helpful. Thank you to all the presenters. Well, there you go. Thank you, Haley. I think I said Holly, but it's Haley. And from Susan Epstein, thank you, Susan, for providing this affirmation. Thank you to all the speakers. Very valuable information shared. Glad you could join us this evening, Susan. And now, just a final thought from each of you, and we'll call it an evening. We'll start with you, Tomeka.
My final thought is the same as always. Take advantage of the resources, get information on all of the things, reach out, ask the questions. There's no such thing as a silly question, and get the information that can help you better help those not only in your personal life, but those who you care the most about.
Jami?
I'll say that it's no coincidence that you came across this Facebook streaming a video. It's no coincidence that you accidentally tuned in, if you had. And so if you do become aware of this video, and I would encourage you that this is a sign for you to go ahead and consider those advanced directives and your estate planning needs. I think Acts 2 is doing an amazing job. And for those caretakers that need help, please, please, please reach out for them, because there's so many resources and you're not alone.
Stephanie Malally?
Definitely being proactive is key, and just educating yourselves like you're doing tonight with this opportunity. As I said, knowledge is power, so keep absorbing all the great information, the resources. And I coincide with Jami, you're not alone in this journey. We're all here to help and provide guidance. So one day at a time, and we love you.
Yes, thank you. And just my final thought is related to the next workshop that we're going to have that I think you might find useful. We're going to focus on recent advances in medications and behavioral approaches to reduce the risk of developing Alzheimer's disease and related dementias. We're going to have Professor Angela Massey Hill, who's the Associate Director of Research at the College of Nursing from the University of South Florida. It's going to be scheduled June 5th. That's Thursday, June 5th, 2025, 7 p.m. Eastern. Thank you for joining us this evening, and my gratitude to Zan Novakoski for their fantastic affirmation. Fantastic presentations by Jami, Stephanie, and Tomeka. Thank you all so much for sharing your wisdom with us tonight. And thank you for all of you for joining us, and have a very, very blessed and rewarding evening.